Hi, I'm Patrick Nugent with IICLE. I'm here with two fantastic friends to IICLE, Pam Lucina and Fred Weber, who are also distinguished faculty members for us. And they're going to be helping us this year do something really important, which is the fact that we have a new statute. And anytime that we have a new statute in the state of Illinois, especially in the estate planning world, we want to be ahead of that game. We want to be in the forefront of that information going back. It is the vision of IICLE to maintain the highest standard of practice guidance for lawyers in the state of Illinois. And you are the volunteers that help us make that work. So I want to thank you so much for doing that for us, first of all. Anyways, we're talking about the Directed Trustee Statute that's coming up. And what I thought we could do is start with Pam, but can you give us a bit of an overview of what that is and how that will affect lawyers in Illinois?
Sure. So Illinois has enacted a new statute that deals with directed trusts that's effective at the beginning of January 2013, although it applies to existing trusts. And what that attempts to do is really, trust law has evolved over the last few years, where it used to be that you would name a trustee that would handle the investments, handle the trust administration, and all of the distributions of the trust. And what people are finding is that there's not always one person that is best suited for all of those roles. So, for example, if you had a family-held business, you may have some person where you want to make distributions that knows the family well, but another person that really knows the business well and you would like them to then direct the investments of that trust. And so over time, what people have done is divide responsibilities of the trustee, or attempt to divide responsibilities of the trustee. But the issue is it's very hard to pluck out one fiduciary duty of the trustee and not affect the other things that the trustee is responsible for doing. And so it's been a little bit unclear who's responsible for what, who has the real ultimate oversight over all of these parties. And so what this Directed Trust Statute attempts to do is to clarify those roles and establish a means of communication between the parties. It is something that other states have had for a while, and Illinois is now enacted one that I think is pretty encompassing of all of the issues that we have seen for years with directed trusts.
It's interesting, too, because I imagine one of the things that, of course, this brings into play, though, is you've got this multidimensional aspects coming in, creating complexities. And I would assume, to some degree, we've got some conflicting issues on that side of the fence as well for the people that are actually in the process of writing and setting these up. So could you talk about that a little bit, Fred?
And I would just say on the administration side, some of the, one of the things that the statute does that I think is really important is that it defines some of these roles. Pam mentioned the trust protector, investment advisor. Some of those roles are now being defined in this statute, whereas prior to the Directed Trust Statute, we saw these offices, or whatever the term you want to use, from whether it's a trust protector or an investment advisor, we saw a lot of that already in documents. But there was no real statutory definition, at least not in Illinois, of what it meant to be a trust protector, what it meant to be an investment advisor, nor any indication as to what the qualifications were for that job. And as you point out, Patrick, when you have multiple parties engaged in service to a trust, starting with the trustee as well as the trust protector and the investment manager and the investment advisor, you often will have the potential for conflict on the administration side, where, typically the role of the trust protector, as I've often seen it in documents, is the trust protector often has the power to remove and replace the trustee. And sometimes it's limited to removing a corporate trustee and replacing it with another corporate trustee. Sometimes the class of individuals who can act as trustee might be defined, and the trust protector could kick out one family member and bring in another family member, that sort of thing. But it's sort of whatever the document said. And where you potentially run into conflicts is what people do is they will take the advice of their attorney and they will name the trustee that the attorney recommends to be the most qualified, but then they'll put somebody in as a trust protector, whether it's a family member or another advisor. And the issue where I've seen it come up is we had a situation where we're administering a trust where the family accountant, longtime family accountant, was the trust protector with the power to remove and replace the trustee. Well, the issue was, in our capacity as trustee, we were a little bit concerned that he was charging a little too much for his accounting fees, and we had to question his fees, which, as a fiduciary, we would be obligated to do, but yet we were questioning a guy about his fees knowing that he had the power to remove and replace us if he didn't think we were serving the needs the needs of the beneficiaries of the trust. So that's a real blatant one. There are others that are less blatant, but you can imagine, you've got these different office holders with different agendas, all of whom are supposed to be working for the benefit of the beneficiaries of the trust, but could very easily find themselves in situations where the decisions they're making might potentially be in their own interests rather than in the interests of the beneficiaries.
So that rather vague understanding of what a fiduciary is becomes a great issue, and who's plugged into what aspect of these directed trusts.
Yeah, and I think it creates, on the planning side, I think it creates opportunities and challenges that on the planning side, people are going to have to really think hard about who they want to put in these different roles and how those people are going to work together and whether they have interests that are in competition with each other.
Right. And I think in some aspects the statute has addressed some of the things that we've learned from having directed trust for a while. So, it used to be we would wonder whether or not the trust protector or investment advisor was a fiduciary. Well, the statute says they're presumed a fiduciary unless you make them not one. It also addresses things about how information is supposed to be shared between the different parties, who's responsible for valuation. So, I think it attempts at least to address some of the concerns or things that we've learned over the past dealing with this either in Delaware or just by drafting. So there are some things that are taken care of, but there are other things still for, as Fred mentioned, we don't necessarily know a succession plan. If there is no investment advisor there, how do you determine who's the next investment advisor? It's very clear for the trust that you turn to the Illinois Trusts Trustees Act and pick a successor, but that's trustees. That doesn't necessarily deal with investment advisors. So there's still some practical considerations you're going to want to have to deal with in drafting.
I know you've done a lot of work for us, and I know you actually are going to be teaching at the annual estate planning short course, which is on April 23rd and 24th here in Chicago with the Hilton Towers. And then we also do that downstate, as most people know, down in Champaign, and that's going to be on May 2nd and the 3rd. We like to think it's the premier educational event for very serious estate planning lawyers in the state of Illinois each and every year. But great thing this year is this is new. This is a new statute. You are doing an hour-long breakout session on it, so thank you for that. I know we're also dealing with another statute change, which is the decanting statute. So that's other new information that we're bringing into this year's course. So that's things that are new, why to come. And then, of course, the other big intangible is not that many of us know what's going to happen on January 1st or 13th or 27th of this year in terms of where we're going to be. And so it should be a very exciting year to come and find out, is there a $4 million exemption in the state of Illinois and a $1 million exemption in the federal laws, or vice versa in any way, shape, or form. I want to thank you both for being so kind to come out and spend some of your time with us today. And hopefully this has helped. Hopefully if you're out there and you're looking at these directed trusts, it gives you some information that is relevant to you. And as I mentioned, it's the vision of IICLE to maintain the highest standard of practical guidance for you so that you can go grow your business, you can serve your clients better, and you can raise the bar for all the lawyers in the state of Illinois.